but welcome everyone. My name is Paul Jorgensen. I'm an intellectual property and contract lawyer here in the Washington, D.C. area. And I'm very, very excited to be here because of all the speeches that I've ever given, I've never given a speech where dogs are actually looking at me, which is so cool, I gotta say. It's really very unique. And it's very unique that even my own dog is in this room, who we'll talk about in just a second. Today we're going to talk about copyrights. It's something that all of you are going to be involved with. It's something that all of you have. And we're going to talk a little bit about the practicalities of it. I know that you probably know about copyright, but you probably only sort of peripherally know about it, and you may have heard of certain things, and we're going to try to bring those kinks out today and so you can kind of understand it a little bit more clearly. I'm also going to try to run through things fairly quickly so that you can ask questions. We'll have questions at the end of the time, so hold on to them. And I've been told by the AV people, since they are recording today, that we want to put all the questions on microphone. So our AV person will bring around a microphone if you do have a question today so that it can be recorded and so the response can be a little bit clearer. So let's start out by saying, this is my dog. And there he is, Sloppy Joe. He's back there. I had originally thought that it would be a great idea just to put Sloppy up on the screen today because he's rather limited attention span. And I didn't think we'd actually bring him, but my wife said last night, she said, well, why don't we bring the dog with us? So Sloppy's going to be here, and I'm really very excited already that he's not listening to me. So what are copyrights? Copyrights are a legal construct. Copyrights are part of the world of what's called intellectual property. Intellectual property is like real property. It's like your car or like your house, but it's not stuff we can touch. It's intellectual. It's up here. It's a distant cousin, in fact, to patents and trademarks. Patents and trademarks are all intellectual properties, but they have different laws. And those laws are focused completely differently. For example, patent law is always focused on innovation. So the idea is we'll give you something exclusive for a period of time in exchange for the idea that you will eventually not have exclusivity over that, and it will improve the rest of the world. Okay? That's my dog making noises right now. So he's too loud. It doesn't matter. I'm fine. Trademark's a little bit different than copyrights too. You may have trademarks. Trademarks are all focused on consumers. What does the consumer see? You all know more about trademarks than you think you do. Every time you go to the store, you make a very quick decision when you're standing looking between two identical products based on the trademark. Something happens very quickly when we look at a trademark. We instantly relate it to an experience that we've had, a positive experience. Okay, so trademarks are really important, but the focus there is on the consumer. And any sort of dispute in the trademark world happens because because the consumer is confused. We don't want to have that. So we have the copyright law is focused on the artist. You are all artists. Whenever you create something, you are an artist. And what you create is called a work. You'll hear that commonly used over and over again. And so we're going to talk a little bit about what can be protected by copyright. Okay, what can be protected by copyright? First of all, it has to be an original and a creative work. That's really, really important. Original and creative. So we're going to talk about what doesn't get covered by copyright, and you'll see that in just a second. But what is an original and creative work? It is a story, an article, a blog, a play, a song, music, a choreography, architecture, sculpture, photography, dance. Any of these things are creative, original works. And then the work itself has to be reduced to a reproducible form. That means that it has to go from here to here, or into your computer, or online. Okay? It has to be able to be reproduced in some way. In other words, you can't copyright an idea. If it's still up here, if it's not ever been reduced to anything, it cannot be protected by the copyright laws. It has to be fixed in any sort of tangible medium. That means on paper, in a picture, on a wall, on the side of a building, in your blog, any of those kinds of things has to be fixed in that kind of tangible medium. And these are some of the things that we see that we can have. They might be software, they might be architecture, they might be blogs, okay? So that's really kind of a neat thing about copyrights, but let's figure out what is not protected by copyright. And as I said before, ideas are not protected by copyright. I hear people a lot. I have clients that come to me and they say, hey, I had this great idea and someone took it. Well, was it ever written down? No, it was just up in my head. Okay, well, going to be kind of hard to prove that one, isn't it? Right? So that's one of the big problems that people have. Another thing that can't be done is lists. If I create a list of everyone who's in this room right now, I do not have a copyrightable work. That's just a list of people. There wasn't anything creative or original about that, was there? Facts. It's just facts. If I say, here are the temperatures for the last 6 days, that's a list of facts. That's not a copyrighted thing. Now, there might be elements on your blog that are purely facts. Let's say you have a listing of 6 events that are coming up in your community. That's not something that can be protected by copyright, that particular list. Doesn't mean the whole blog can't be, and we'll talk about that in a second, but those facts alone. Trademarks are not protected by copyright. If you have a splendid trademark that names your website, that's not a copyright, that's a trademark, it's a separate issue. Titles, if you have a title to a particular article that you have, or even a title to your book, titles are not protected by copyright. Doesn't mean they can't have protection, it just means that the copyright laws are not going to be the ones that do it. Slogans, if you have particular slogans, or procedures, or even US government works. These things are not protected by copyright. So for example, if you do want to put up on your website something that comes from the US government, that is a US government publication, fine. It's not protected by copyright. There's no issue of whether you have to get permission first. So, you know that your blog might be protected by copyright. What do you have to do to protect it? What are the magic things? Now, okay, I'm going to just save you a ton of money by going to a lawyer here. All right? Because this is exactly what a lawyer would tell you, but they would tell you like over the course of like 6 weeks. All right? So this is what you do. You put a copyright notice, which is that nifty little C in a circle. It's not an R in a circle. That's a trademark, okay? Don't do that. That means you have a registered trademark. It doesn't mean it's registered, so don't do that. Copyright, you put the year. All right? So that's the year it was created, the work was created. So if, like, for example, your first blogging was in 2009, it would be copyright 2009, and then the owner. Now, that owner could be you individually. It might be your company. It might be a group of people. Whatever. Whoever owns that is something that you want to put up there. You put that copyright notice where? Where do you put it? Well, you put it up on your front web page. Put a copyright notice on your web page. And a good rule of thumb is you don't have to stick it on every page that you put on your blog. It doesn't have to be on every one. It has to be on anything that can be separated from each other. So let's say I have a book, and it has chapters. And somebody might want to use chapter 6 because it has really good training methods in it. And they want to take chapter 6 out of it. And they take it out of there. Well, that would probably be a good thing to have at the start of chapter 6, the copyright notice there, too. Don't overkill it. You don't have to put it on the bottom of every page and everything like that. And besides, if it's in one place and the dispute comes up, you can always say, I had a notice on it. Okay? No one can say, well, you didn't have it on page 6. All right? They could, but the courts would tell them to go away. Do you have to register a copyright to get protection of the copyright laws? Here's the great answer, no. You don't, okay? Trademarks get special privileges by registration. Patents must be registered in order to be protected. But remember, those are distant cousins from what we're talking about here. Copyright does not need to be registered to be protected under the US copyright laws. It subsists from its creation. It starts as soon as it gets from here to here. All right? That's pretty cool. That's one great thing about copyrights. So who registers copyrights? Because people do. There is a copyright office, right? Okay, well, there are people who are in highly competitive industries that are like the music industry, the film industry, and the literary industry that really just as a matter of course send in their little thing to the Copyright Office. Is a copyright registration easy to get? Absolutely. It's simple. And in fact, if you're going into a dispute that involves a copyright and you don't feel really comfortable with the idea that your copyright isn't registered, you can do it literally as you head to the court. Okay? And it costs $50. It's very simple. The process is very easy. You can do it online. Go to the US Copyright Office. It is in the Library of Congress. It is something you can do yourself. It is not something you need a lawyer to do. If you need to have any information, they have ridiculous volumes of information that are really, really well written. It's very simple to do. Okay? So literally, as you're in a dispute situation, that may be the time you want to think about registering a particular copyright in a work that you have. But up to that point, you're not in industries where that is going to be a real big issue. If you start dealing with the music industry or something like that, yeah, you might be starting to think about it. The other thing you want to do to protect your copyright is to license and give permission carefully. And we're going to talk about that in just a second, about getting permission and giving permission. But you need to think through that. As bloggers, you are publishers. You are writers. Okay? You are creating these wonderful pieces of work that are just like the Mona Lisa or anything else. You may not think that, but that's what you have. And because you have that, you need to think through the process of how would I give someone permission to this? Don't wait till the last minute. Think about it now. Come up with just a 4-step process that you might want to have about how you would review that thing and do that. The reason you want to do that is because you want to be ready, and you also want to be consistent. You don't want to do one thing for one person and another thing for another person, because what happens, you get in a copyright dispute later on, they're going to say, so tell us how many permissions have you given out? Tell us how you did that. What were the limitations of them? And if you appear to be inconsistent in the way you've behaved toward your works, ain't going to be good for you. Don't want to have that happen. Okay? So that's something that we're going to talk about a little bit more when we talk about permission. Policing and defending your copyrights. As soon as you create intellectual properties, you have created pets. I like to tell my clients that not only because I'm a dog person myself, but you've created pets. Your works are like your pets. They have a life. They were born at a certain time. They require care and feeding, and they require that you police and defend them. Okay? You wouldn't get into this world if you didn't realize that that was a possibility. And now you're here, you got to know that you got to police and defend them. How we're going to do that, we'll talk about in a few minutes. So these are the ways you're going to actually protect your copyrights. So big deal. I have a copyright and I have a protection. What are the copyrights? I don't know how many times I actually say the word copyright in this speech, so it seems like an awful lot already, but what are the copyrights? The copyrights, I want you to think of a bundle of like sticks. And the copyrights are a bundle of rights. And they are ones that you can give out to someone permanently. You can loan to someone. You can give all of them away, or you can give some of them away. But when you create a work, you have rights. Now, what are the copyrights themselves? Your first and biggest right is the right to reproduce the work. You hold on to that. If someone says, I would love to reproduce your work in any way, you would be giving them one of these sticks. You might be giving it to them for a short time, a one-time only, any of those kinds of things, but you are going to be giving them part of your copyright. It might be coming back to you. That's the biggest one. The next one is the right to distribute copies of your works. All right? The distribution of any sort of work is a point at which a lot of people start to see it. Think of a piece of artwork. If a piece of artwork is created and it sits in someone's studio, not much happens. But as soon as we distribute it, we start taking it around and we start showing it to people. That's when things happen. That's when people know about it. That's when they get excited about it. So you hold that right. You can also prepare derivative works that are based on the work. What's a derivative work? A derivative work is something that uses the basic work as a core, and then it creates a thing around it. Here's the best way I can possibly describe it. You all know Andy Warhol, right? Andy Warhol had a great career in taking photographs of people, even the Mona Lisa, and reproducing them several times and doing all kinds of cool colors and putting lipstick on the Mona Lisa and all those kinds of fun things. That was a derivative work. He'd taken an original work and he'd incorporated it into a larger work. That's called a derivative work. As the copyright owner, you all have that in your bundle. You can do it yourself. Let's say you create a story, one of your stories or one of your works. And later on, you want to make that as a basis for a book. Okay? That's a derivative work of the original work. And you have the right to do that. If someone else wants to base something on your blog, say they want to come and they want to do a movie that's based on your blog, hey, well, first of all, great. I want you to call me if that happens. But if it doesn't happen, but that would be a derivative work, okay? And you would be the one who was in control of that as a part of your bundle. The other thing is to perform and display the work publicly. That would be, I can put my picture on the wall. I can put my blog up on the internet. I can perform my play or my dance publicly. That's one of the things that I have. Now, there also might be some special copyrights that you have in the work. And that would depend on what kinds of things you have. Like, for example, in the television world, you might have serialization rights. So let's say I have this great show and somebody wants to create a whole serial based on it. Okay, well then serialization rights might be something, or pay TV rights or things. There are a whole bunch of copyrights, but these are the core that you need to know about and the ones that you need to know in case you're going to do anything about licensing or things like that. So you know what you have now. Those are the special rights. You know what you have now. What can you actually do? Let's shift seats from the person who owns the work to the person who wants to borrow it, or the person who wants to use your work, or if you want to use someone else's work. Now, you are all probably in both seats at one time or another. You either are in the position of having people want to use your work, or you want to use someone else's work. So let's figure out, how can I use the work? How can I borrow the work? And let's take a little bit of a quiz here. If I wanted to borrow a work, these would be the three things that I could do. Take all of a part of a work, put it in my blog without attribution. Take all or part of the work, put it in my blog without attribution, or get permission or a license to use the work and put them in your blog. All right, I know y'all, I'm not even going to ask you which one's right here, because y'all know it is this last one, right? The first two you probably could do in certain circumstances, but they're high-risk behavior. And if you ever consulted with a lawyer, that's probably what they would tell you. If you want to take that risk, you might not get caught by anybody, but you may actually get caught. So what kinds of things would happen? What could possibly go wrong? Sloppy's not in the room now, but if he was, he might be sleeping. What could possibly go wrong? Well, you're really unlikely to know with certainty about the nature of what you borrowed. If I go out and I borrow someone's work without attribution, I might not get something right. I may actually have a compound work. I may have borrowed something that somebody else borrowed something, so I may get in trouble with not one but two people. If I get proper permission, I'm going to be getting a representation from the person who gave it to you that they have the ability to give you that permission. You're going to have that as part of your deal. You may also invite copyright lawsuits. We all know, we've all heard about copyright lawsuits. It's not something you want to get involved in. It can be long, it can be terrible. The bad thing about any intellectual property lawsuit is discovery. And I don't know how many of you know about phases of courts, but when you go into a court, after the initial things have been filed with a court, you go into this period called discovery. And that means that everybody gets to ask for documents and sit and ask each other questions. This is the part that lawyers love because we just run up our bills at this point. You don't want to be on the other end of that bill. So copyright lawsuits can drag out because they have these huge discovery periods. When did this happen? What did you give them? What are the dates of this? Show me all the copies of this. It's terrible. You don't want to get involved in it at all. You also might be penalized if you borrow someone's stuff without attribution and without permission. You might be also penalized or banned from the search engine, which may lower your search engine ratings. And you don't want to have that happen at all. So I know one of the things that you want to say is, hold on, I didn't mean to do anything wrong. I just borrowed this. Can I use other people's works for some reason? Aren't I protected by fair something? Fair use? I've heard of that before somehow. Okay, all right. We're going to go through the ways you could actually be protected. Lawyers will, if you come to a lawyer and you've actually accidentally borrowed something, they're going to say, well, it depends on what kinds of things might protect you here. So there are a couple of ways that you actually can use a copyrighted work. And this is how we're going to do it. First thing is a statutory exemption. I would encourage you not even to write this down, because unless you are a library, an archive, or you're going to use the work for face-to-face teaching activities at a nonprofit institution, you do not qualify for the statutory exemption. That means you cannot go borrow someone's work and say, oh, statutory exemption, I'm a library. Okay, you can't do that. But if you are a library, great. Go at it. Go crazy. Next thing, you have a couple other ways you can actually borrow it. You can say, I have First Amendment rights. Doesn't this sound great? I always like to do this one. This is the First Amendment, right? We have a right to free speech, right? Okay. It sounds really important, but I encourage you not to hide behind the First Amendment. It's really something that is reserved for purely political reasons. You're using something for a purely political reason, or you're saying something for a political reason. Cannot be commercial in any way. If your website has anything that has anything commercial on it, you're out of the First Amendment world. Sorry. What happened to the dog? Did you dump him? Oh, great. Oh, excellent. Thanks. That's great. Fantastic. I want to go back to this. The other thing about First Amendment is, some people try to say it's purely political use. You guys can probably remember, there was a case a couple years ago. Sarah Palin borrowed the song Barracuda for her campaign, okay? Ask her whether she got away with the First Amendment defense. She didn't. She didn't because it wasn't. It was not for purely political reasons, and she didn't get permission. And you know what? The court got very angry because they said, you're lazy. You didn't go and simply get permission from BMI and ASCAP, which is a very common thing to do when you want to borrow music. It's not that hard. So it was a real slap down. So don't hide behind this. Yes? Uh-huh. If your agency is does political work, purely political reasons means that you are speaking out about a particular political issue from a political standpoint. Every part of it has to be political. You can't have a commercial element to it at all. So it's one of those things that a lot of people will bring up in a copyright case, but it's one of those things that the court quickly passes by, unless it's very, very clear that your organization is doing something purely for political reasons. Best thing is don't ever rely on it. Yeah. So what else can we hide behind if we want to borrow something? Parody. Parody is great. I love parody a lot. Parody is when we're doing things that are making jokes about something. Now, to use parody effectively, you have to show that it is a literary criticism, social or literary criticism. You have to say that there is some socially significant value to what you're doing. And you have to say that your parody was reasonably perceived. In other words, everybody knew you were joking. okay? When you put up that parody of somebody's novel or something like that on your blog, everybody knew you were joking. And who do we actually look at when we say that? Well, we look at the court. You've got to convince the judge that he or she finds this absolutely hilarious. All right? And if you feel like you can do that, then you can kind of hide behind parody. All right? So that's probably not your best tack. So now we're going to get into fair use. Fair use is probably the best way for you to go and use things or give other people, or understand when other people borrow your stuff, whether it's fair use or not. Now, I'm going to warn you, fair use is not an easy thing to understand. It is not a black and white thing. You can't simply just say, hey, fair use. I borrowed 3/4 of your blog, but hey, it's fair use, right? You can't say that. It's just not an automatic thing. The analysis, if it comes down to it, if the argument comes down to someone else in the middle of you and the other person in a dispute, the analysis will be something like this. 4 teeter-totters. It's what I want you to remember. Every time you talk about fair use, I want you to think about 4 teeter-totters. And 4 teeter-totters, they all have to be leaning toward you in order to make it fair use. And we're going to go through each one of the teeter-totters. But it's 4 different pieces of analysis to know that it's fully fair use. It would be best if all of them are leaning toward you, because then you could say it was fair use instead of all of them leaning away. If you have 3 of 4, you've got pretty good grounds to say it's fair use. But this is the analysis. It is a 4-part analysis. So what is fair use? Purpose of use is the first thing. What is the purpose of you borrowing this or someone borrowing this from you? That's what the court's going to look at first. It is not fair use if your use or their use is commercial. It's not fair use if they profit from it or you profit from it. It's not fair use if it's entertainment. And it's not fair use if there was bad faith involved. Any of those things happen and that teeter-totter is facing away from you. Now remember, we've got 3 more things to look at, but this is pretty bad if you're already in a bad place right here. What is fair use? Oh, you also deny the author any credit, or you supersede the original. In other words, you're simply reprinting the original. Okay? What is fair use? Okay, if I'm in a nonprofit situation, if I'm borrowing something in a nonprofit situation, if I'm a library, or I'm borrowing something that is going to my nonprofit organization, if my use is for educational purposes, if I actually am trying to teach someone with this, or teach animals with this, if you would like. There's a public purpose to the reason I've borrowed it. There is some scholarship involved. If I'm doing my master's thesis on a particular type of dog training, and I borrow things for that master's thesis, it is meant for scholarship. I do have fair use in my favor, at least with respect to this analysis. And then it also is for personal use. If I'm just borrowing it to put on my refrigerator, good stuff, that's probably going to be fair use. Yes? Yes? Okay, remember, we're not done. We're not done, okay? But that's 1 strike against you. Yes? Yes. Right. The fair use was the picture that Shepard Fairey borrowed in order to do the Hope campaign poster. Was that fair use? And the court went through this analysis, the 4-part analysis. And for this first part of that analysis, he did pretty well. He did pretty well because he was more on this side than he was on this side. But let's see what happened next. Second thing they're going to look at is what is the nature of the use? Okay, how was the work used? It's not fair use if it was creative, original. Oh, I'm sorry, this is the nature of the work. The nature of the, not how it was used. This is what was borrowed. Okay, sorry. What was borrowed, if the original was creative, original, not published before, if it was fiction, those are not fair use. If you are borrowing facts, you know, the Consumer Product Index this month says X, we're up this percentage or something like that, that belongs to the fair use realm. If it's incapable of copyright protection, if I'm publishing a list, remember what we talked about, what was capable of copyright protection and what wasn't? If it's incapable of copyright protection, I can probably borrow it under fair use if it's been published, and if it's important to a favored educational objective. That one sounds like what a court came up with. In addition, they definitely did. That means I'm using it usually in an educational realm. Okay? So this is analysis number 2. What is the nature of the work? The next thing is what they're going to look at is how much of the work was used. All right? Did you borrow 6 words or did you borrow 6 pages? So it's not fair use if you borrow all or a substantial portion of the underlying work. All right? If somebody borrows a quote from your article, probably going to be okay. Portion is central to the work. The part that they borrowed, let's say they borrow the last part of The Great Gatsby, and that's central to the absolute part of the whole work. That's where the work comes together in those last 2 pages. And they borrow that. That portion is so central to the work that it almost ruins the whole thing. They're borrowing the best part, in other words. So that's not fair use. If you use a small or insignificant amount of a work, let's say it's this photograph over here, and maybe I just use this corner piece right here that's this big. Not sure why I would do that, but if I did, that's a small or an insignificant amount. I doubt it I'm going to run into a copyright issue. Portion is not central to the work. Okay, I'm not borrowing the middle part of that picture. I'm borrowing just the corner part of that picture. It's not central to the work. Maybe it's not even identifiable as the underlying work. And it's appropriate for the purpose that I have. Something that is that I'm borrowing just the amount that I need. I didn't borrow 16 pages when I really only needed a paragraph. Okay, that's part of the analysis that they're going to see. So we're on the 3rd teeter-totter here. We got to move into the 4th one, and that is the effect of the use. All right. Now this is what happens because you borrowed it. This happened. All right. It's not fair use if you deny the creator some economic benefit. If someone republishes your wonderful blog piece and you were going to turn that into a book that you were going to have economic benefit from, that would not be fair use. Okay? They've denied you the ability to do something commercial with it. Whether or not you were actually planning it or not doesn't matter. But that's not fair use. You avoid payment in an established market. Okay, if we go out and we get photographs or music and we borrow them from somebody, this is an established market. Everybody knows that if I borrow certain photographs, I have to pay for them. Or if I borrow music, I have to pay for that. That's an established market. We all know those kinds of things, or we should know them. And so we want to make sure that it's not fair use if somebody just avoids paying for it. This goes back to the Sarah Palin thing. They could have easily paid for that. They didn't, and they avoided that. So that's not fair use. That there is a reasonable use mechanism. This means that in the industry they have a way of licensing. You can go to a website and you can click on, let's say you went to Time Magazine and you went to their website and you wanted to use a portion of an article. They have a button that you can push that is specifically for copyright requests. This is an established reasonable use mechanism. And it might be something that if you get a lot of requests, you may want to establish some sort of use mechanism, which might be a license. It might be a part of your website or whatever. Yes? Yes, it is not fair use if there is a reasonable use mechanism and you have simply walked away from it or ignored it. Exactly. That's a very good distinction. And it's affordable. In a lot of cases, sometimes you can't go out and buy your favorite song from the 1970s, but because it's too expensive, but in most cases things are relatively affordable. If you've avoided what is an affordable permission process, which is either free or reduced price, then that's not fair use. And then if you made numerous copies of it, if you've taken this out and you have splattered it all over everything, that's not fair use. It's same as distributed wildly and repeated it. So what is fair use? If you can say that your use had no significant effect on the market or the potential market for that work, that's great. Maybe if you borrowed a quote, you actually enhanced the underlying ability, the underlying work ability to get into markets. So it had no significant effect. You didn't block them from making money or from distributing or doing any of the other things that they had the right to do. That you lawfully acquired the original, that you came into it because this was a work that was in your great aunt's house, and it is always hanging on her wall, and she bequeathed it to you under a legal will, and fair use because you lawfully acquired the original. Now, still, you still have to work with the artist and things like that. You made limited use of it. One or a few copies were made. And that there is no similar product out there that is marketed by the creator. All right? If you're going to use something in a blog and it's coming from a blog, that's a similar market, so that's going to cut down on your fair use. So these are the 4 items that you have to have. And I know this is very complicated stuff, but I wanted you to appreciate that fair use is not something you can just say. It is something you have to walk through the analysis. And that means that if somebody borrows your work, you also need to think about all of these things and see which way the teeter-totters are going before you start lashing out and saying, I want to stop them. Okay? You want to be very, very practical, and this is going to help you to be practical about the whole thing. Now, so what is fair use? I want you to remember that it is the 4 things, but it is not this bright line rule that everybody wants you to actually believe. Now, before we go on to questions, I want to address one more area about copyright. And this is what happens if my work is taken? What are the practical steps that I can actually take to do everything, or to protect my work if I find out somebody has taken it? These are the things you need to do. First thing you need to do is remember, document everything. That means write down dates, write down times, write down everything. If you have screenshots of something that has been taken from you, make sure those screenshots are captured and dated. Okay, these are all going to be very, very important if you get into a dispute. I'm not saying you're going to, but collecting this information is going to give not only you a practical view of how many facts are in your favor, but should you ever work with a lawyer, the lawyer's going to have you do any of this anyway. So document everything you can do. So you want to do basically documenting of these things. Which work was stolen? Okay? You need to be able to quickly say, this was this thing right here, this picture on the wall was the thing that was taken. And that was created on May 1st, 1979. And I have a copyright in it, because I created it and it went from here to here, right? Okay, so which work was the first one? How much of the work was taken? You need to figure that out. Was it all of it? Was it a single line? Was it a paragraph? When did you find out? That's going to be very important too, because if you find out on January 1st of this year and you don't act until May 18th of this year, most courts are going to say, I'm not really believing that you're really damaged. I'm not really believing there's any problem here because you didn't act awfully fast, did you? So you have to figure out when you found out about something. That's not actually when it was published or when it was stolen, but that's when you found out about it. Okay? Did you have a question there? Not necessarily a statute of limitations. It's a good question. It's not necessarily a statute of limitations. It's just in intellectual property world, there is a vigor in which you have to prosecute something. It's not like a statute of limitations implies that there's a particular law that's on the books that has to be enforced within a period of time, or it would mean something that the person who's accused of it would be disadvantaged. We see that in murder cases. We see that in robbery cases. Any of those kinds of situations. Not so much here. It's just that you need to show vigor. Who took it? And you're going to have to do as much research on who took it and how. And were they the first person? Where did it actually appear? Where was it reproduced? Where did they use one of your copyrights, one of your sticks in your bundles? And was there any permission given? All right? All those things are going to be very, very important, and they're documenting those are going to be absolutely essential, because as you do this, you're going to start to see, oh, you know what? I think I gave that guy permission back last year when I was at BlogPaws. Oh, crap. All right? So you just saved yourself a trip to a lawyer's office, okay? That's good. Not that you would do that or anything like that, but next thing you can do is you want to assess either directly or through a lawyer sort of the things that a lawyer is going to do. Lawyer is going to look at all your facts, and they're going to say, okay, you have a strong argument, or you have a medium argument, a weak argument. They're going to also look and see whether the other side has any defenses. Okay, go back to fair use, go back to parity, go back to First Amendment, all those kinds of defenses that we talked about. And what they're going to do is they're going to say, okay, it looks as though they have some fair use defenses, but only 2 of the 4. So they're going to give you an assessment of, well, should you expect to win if you go forward with a case? What are the defenses? The next thing that you want to do is contact the thief directly, or have the contact through a lawyer. What's the contact look like? First of all, it's always in writing. People, do not call people on the phone, because first of all, we lose it when we're on the phone. I do. When you're writing, you're a lot better. The other thing is, when you're writing, you got a date on it. This is the first day I contacted you, and you're creating what's called a paper trail. You want to do that. Okay, so you want to create that paper trail. Next thing you do is you don't threaten when you find out that half your work has been stolen. I know this is your blood and guts. I know this is a visceral thing for you. You have to think of it as a separate item from you, and you have to kind of distract yourself from that feeling of being stolen. Okay? You want to ask very directly and very politely. You want to say, this is when we found out about it. This is what we found out that you have taken. We did not give you permission for this. Please write us back and tell us why you did this. Okay? That's a lot better than saying, cease and desist. Lawyers love that. Cease and desist. Oh, good Lord. Never. If the lawyer says, I'm going to write a cease and desist letter for you, please call me instead. Really, it's not something you... Cease and desist letters, you know what they do? They put people into the corner. You paint yourself into the corner where people get very defensive. And they start to fight back. They start to fight back at you, whether or not they're actually logical or not. And they'll get lawyers involved, and suddenly the prices of everything is going to go straight through the ceiling. You do not want the cease and desist letter. You want the notice letter instead. And after a while, you could even develop your own notice letter if this happens to you frequently. You can have a form that you basically send out. You know exactly what to do. So you're contacting the thief. You're asking them what their basis is to use it. You're inviting their response. If they do not respond to you, then you have something to do. If they do respond to you, then you have something to do. So there's a couple of things that happen when that happens. And we can talk about that, especially in questions. You also want to appeal to a higher level. If this is published online, is there a way to go to the publisher? Who published this? Can you use the Digital Millennium Copyright Act to stop this person? Can you ask them to have the webmaster take this portion down if it is indeed being abused on the internet? Are there ways to do that? So in other words, you want to find out not only the thief, but the person who's helping the thief do one of your copyrights. So if there is this person there, you also want to make a direct appeal to them. And the letter to them basically says, I'm the owner of copyright X. On such and such a day, I found out that this copyright was being used. There was no permission given. I would like you to take it down. Okay? You're going to have varying degrees of luck with that, but a lot of times webmasters, things like that, don't want to be involved in copyright cases. They start smelling copyright, they're going to take something down. Oftentimes a very simple way of getting around this. That, again, does presume that your problem is on the internet. It may not be. It may be in hard copy. So let's do a quick review, and then I want to open it up for questions. Best thing is you have copyrightable works. You have a bunch of them probably already. Unless you're starting blogging tomorrow, you probably already have a lot of copyrightable works. You can say that those are your intellectual properties. They are anything that's gone from here to here and has that creative element in it is a copyrighted work. You can and you should protect your works. You should do that by understanding what you can and cannot do and how to police your works, what's a good method of doing that. You should license and loan your works very carefully and consistently. If you're going to give people any rights to your works, make sure that you do it very carefully and consistently and that you keep track of it. So for example, if I'm going to give someone a year license to use one of my works, I want to know when that year's over. So get out your calendars and write it down. Okay, so if something goes beyond that year, you know. All right? So license and loan carefully. Licenses don't have to be huge. They don't have to be massive. Any lawyer that tells you that they have to be massive or large, walk away again. It can be a very simple one-page type of thing where you do licensing. Okay? And then finally, you need to borrow with permission. I always love this. I always have clients that come to me and go, well, we would just want to borrow this one little thing, and we walk through the whole fair use kind of thing, and we realize there's pretty high risk behavior in this. And I said, you know, in the time that it took for us to talk about this, you probably could have got permission. Most people, especially when they find out what you want to do with their work, how you want to use it, especially if you're doing it for good things, which all of you are doing, they're going to want to give you permission for it, and oftentimes without any cost. So you really need to get in the habit of, if you're going to borrow with permission. You'll also be known as a person who does that, and people will be more likely to give you permission in the future. So those are the big issues that you should be looking at. One more picture of Sloppy Joe. My favorite picture of all time. I like it because he's actually airborne. I hope that we can get him back. Did you sell him for much or what? Where did you put him? I'm really worried about him. He's gone somewhere. He makes a lot of noise. He can't help it. His face is all mushed up. But anyway, oh, by the way, I hope you did notice this. This is the best photograph I've ever taken. So copyright notice. And that's all as much as you need right there. Okay, now I'm going to have the microphone come up, and I want to answer questions. It looks like we've got a bunch of questions. And if I don't get to everybody today, you can always give me a call. I'm here in Washington, D.C., and the nice thing about copyright laws is they're pretty much uniform all over the country, so there's a lot of the same issues come up everywhere, so I can probably help you out. Yes?
Hi, Jana Kelly. I write the blog Pause and Effect. I have two questions. First of all, I took a photo of your final slide. May I post it online?
I give you permission, yes.
Secondly,
But see, that was great. She asked permission. And if I'd found out about that, oh man, she would have been in court. No, I'm just joking.
Yeah, right.
Joking.
And the other question I have is, I've seen some websites where on the copyright date, they'll say like copyright 2007 to 2013. Is that really necessary?
No.
Or, okay, so it's
no,
just
it's not
copyright
necessary.
from
What people were trying to do there is they're trying to say that this is a multiple work. And indeed, yeah, it's very true that maybe you started creating something in 2009 and your latest creation was in 2013. You don't have to have that range up there in order to have protection for each one of them. If your work can be segmented and taken off, it should bear a copyright notice itself. So, and that copyright notice would be the year it was created. But you don't have to have the whole website as, like for example, I have some materials on my website copyright notice basically says copyright notice 2007, because that's when I started creating them. So,
Okay,
yeah.
but so should I have a copyright? Like, say I started my blog in 2003, so I would have my entire blog copyright 2003. But if I wrote a blog post last week, that's what you were saying.
You're fine. You're covered.
Okay, all
You're
right.
covered. You're covered. And in fact, I think what you probably want to do is have on your blog, if you have links across the bottom, and if there's a, maybe one of them just needs to be says copyright, and that jumps to a page that has just a simple paragraph on it. You can go to any go to any website and you can pull one of these off. You can pull it off my site. Okay, go ahead. But basically says, anything on this site is copyrighted. You need to get permission from me if you want to reproduce it. And it doesn't have to have legal words in it. It doesn't have to have heretofores and whereases. It can be your own voice. Basically says, this is my work. Get permission from me before you actually use it.
Thank you.
You're welcome. Thank you. Yeah.
I have a question related to, let's say, your photograph that you just put up there. There's a preponderance of cute quotes that usually go with those. Some are from, let's say, Walt Whitman, and some are from Maya Angelou. Which one violates copyright, or do either one of them violate copyright?
Probably not. You're talking mostly about memes. And memes are something actually I had to ask my college-age students to explain to me, because I did not understand what they were until I started seeing cat has cheeseburger or something like that, Oh, okay, that's a meme. Okay. Memes are really hard to protect because they go out so quickly. And I doubt that there's probably too many people out there who create a meme who have the expectation that they want to keep that as copyrighted. They usually use photographs that are in the public domain. Remember, when we send out photographs and things like that without copyright notices, and unless we're going to be willing to protect them, they're going to get out there. One of the difficulties that we live in right now is we are in this great frontier where things just slide out. And if you ask a lot of very young people today about copyrights, about the notion of copyrights, they will blank on you. They don't even understand this notion that everything hasn't always been available and that it ever originated with one person. To go to your question about the quotes themselves usually, especially if they are famous people quotes, Walt Whitman, Maya Angelou, or something like that, if you are borrowing just a quote, it's very unlikely that that quote is a copyright or protected by copyright. The expectation of that person who made that quote, it was probably not that they were going to copyright that quote. Gandhi, when he said something, probably didn't go, hey, my lawyers are behind me, they'll get a copyright in that. So that's probably something you can do without much problem, especially if you're going to do attribution. Walt Whitman, I doubt the estate of Walt Whitman is probably still around. But you do have to be careful. Sometimes if you do a quote from Frank Sinatra, you will get a call from the estate of Frank Sinatra. So be very careful. Understand that some of your people are going to be a little bit more, even if you're protected by copyright, you're not protected from lunacy. Remember that. You can say, well, I have the law on my side. That's great, but you're not protected from somebody who's still going to come after you and bother you. So, yes. Yeah.
Going back to the picture,
Uh-huh.
I started watermarking my photos, but instead of putting the year, I just put my blog name.
Okay.
Is that still all right?
That's fine. That's fine. You can do that. I mean, there is no magic to this. This doesn't suddenly make everything perfect. It's fine. You should be okay with that. Because you can still probably say, if there was a dispute, God forbid, but if there's a dispute, you could still probably show, based on your watermarking and probably the way that cameras take things today, show exactly when you created that and then it came out of your camera. I don't think that would be an issue. This is sort of an arcane idea that's left over from the times where things literally came off printing presses. And the only way to actually control the origin and the rights to those works was to put that notice on there.
Okay.
Yeah.
In your beginning, that's why I started watermarking my photos and even my posts sometimes. 3 years ago, about 3 years ago, some of my posts and photos In the beginning, you mentioned something about copyrighting the website itself, or
Yeah.
the URL.
Yeah. Well, actually, the URL itself is what's called a domain name. The address is a domain name. That domain names are protected in a different way than copyrights. They're closer to trademarks. Because again, when people come to www.jorgensenfirm.com, they are choosing that because of a positive experience or reference that somebody gave them. Just like somebody comes to your blog because they love your work. They think it's the greatest. They think it's, and they've had a good experience for it. That acts as a trademark. And domain names are protected by two things. One is they're protected from cyber squatters and other people who are trying to benefit from them. They're also protected by trademark law if they rise to the level of a trademark. So for example, www.coca-cola.com, probably going to be protected because the underlying words are protected as a trademark. So yes, you can protect URLs, but it's under a different type of law. You can copyright the entire website. I mean, yeah, the website itself can be copyrighted. It should have that copyright notice on it. But yeah, it's basically everything that's on it. But remember, within that website, remember you're creating not just a single work when you create a blog site. You're not creating just this. You're creating lots of different things. There may be lists within that are not protectable. There may be facts that are listed on there that are not protectable. You have to adjust yourself within your site to what I can protect and what I can't protect. And what you're looking at is the most creative elements of your site are the things you can protect by copyright. The least creative are the ones that you have a low expectation of copyright protection. Okay? Yeah?
I'm from Lupine Collars and Leeds, and I do most of the social media for them.
Uh-huh.
And I guess my question kind of feeds off yours in the way that we would like to be able to share memes and feel that that's valuable to our consumers, and everybody likes to laugh at them.
Uh-huh.
However, most of those phrases, maybe they're not written by famous people, but we recently had an issue where the photo was extremely photoshopped, so there was no way for me to Google Images to make sure that it wasn't a Getty image.
Uh-huh.
And then that takes it a step further, that now we're concerned that we would love to share your meme and hopefully gather likes to your blog and what have you. But since we were billed from Getty for $1,000 now,
Right.
we're a little scared
Gun
to
shy.
continue
Yeah,
that.
absolutely.
And are there sites other than searching Google Images and hoping that the photo has not been modified enough to?
As far as we have come, and how easy it is to access tons of images and tons of information, we still have no one definitive way of taking all the information and finding out whether something is subject to copyright and those kinds of things. I guess the best rule of thumb is always do your best to do the due diligence to find out whether there is someone who has title to the underlying work. After that, you got to step off the edge of the dock and you got to take some risk. If you're not willing to take that risk, if you've been bitten too many times by somebody who comes back and says, you now owe us $1,000, then don't do it. Don't just default to the no. Default to the no. It's not worth it.
No.
It's not ultimately worth it. It's not going to bring you that much in terms of fame or readership or anything like that in comparison to the legal issues that you can face. It's not worth it. So, pass back.
I did a social media internship for a large commercial real estate firm, and they were very heavy bloggers, and they wrote very professional blogs about current trends and topics in real estate and healthcare, and they always just linked back to their sources.
Uh-huh.
And they said that was fine, that covered them from any copyright.
I'm guessing that the reason that they did that was, first of all, that was a good idea, doing links. Second of all, they were probably publishing in the real estate area and in the healthcare area, they were publishing probably a lot of facts. So they were probably saying, according to the most recent study, there has been this much, there's this many house sales in the Bethesda area. And that's a fact. It's not a copyrighted thing. So they can do those kinds of links without much worry. And in fact, you all can as well. So if you're going to have something on your website where, yeah, you want to quote facts and you do the link, that's a very nice thing because you're giving that attribution and you're also giving the person the opportunity to link through to the source, which is really wonderful. So, but don't link to creative stuff. If you're going to quote without the permission and without the attribution, linking through is not going to protect you. You can't.